On the morning of March 14th, 2021, in a county courthouse in Tioga County, Pennsylvania, a 58-year-old dairy farmer named Emmett Vandermere stood before Judge Harlan Pickering and watched his family's 240 acres slip toward foreclosure. The bank's attorney was a man named Roy Thurmond. He was 41 years old, wore a charcoal suit that cost more than Emmett's monthly milk check, and had filed 317 successful foreclosure actions in the previous 11 years. He had not lost one. He did not expect to lose this one. Emmett Vandermere had no attorney. He had a manila folder. The folder contained a single yellowed envelope. The envelope was sealed. It had been sealed since November 11, 1953. The bank had filed for foreclosure on the basis of a delinquent commercial agricultural loan, originated in 2017. Current outstanding balance $492,000. The Vandermere farm had been used as collateral. The bank had every legal right to seize the property. The judge had read the documents the night before. The judge had already made up his mind. What Judge Harlan Pickering did not know, what Roy Thurmond did not know, what nobody in that courtroom knew, except Emmett Vandermere and the ghost of his grandfather, Wendell, was that the envelope in the manila folder contained a letter that would not just stop the foreclosure. It would make the judge apologize. In open court, on the record, it would close the bank's regional office within 90 days. It would force Roy Thurmond to resign. And it would change the way every commercial agricultural loan in northern Pennsylvania was written for the next decade. But on the morning of March 14th, 2021, none of that had happened yet. What had happened was this. Emmett Vandermere had walked into a courthouse with a letter his grandfather Wendell had written on the night of November 11th, 1953, and had instructed his son Garrison to keep it sealed until the bank came for the farm. Garrison Vandermere had kept the envelope sealed for 63 years. He had given it to Emmett on his deathbed in 2016. Emmett had kept it sealed for another 5 years. That morning, in his pickup truck, in the courthouse parking lot, Emmett had taken out a small folding knife and cut the seal. He had read the letter for the first time. He had read it twice. He had wept once. Then he had put it back in the envelope, walked into the courthouse, and waited for his case to be called. This is the story of what was in that letter. And it is a story of what one farmer's grandfather knew in 1953, that the United States Federal Reserve, the Pennsylvania Department of Agriculture, and the legal department of First Allegheny Bank had collectively forgotten by 2021. To understand it, you have to go back to a Tuesday afternoon in the autumn of 1953, to a kitchen table in rural Pennsylvania, to a man in his early 40s writing a letter by the light of a kerosene lamp because the rural electrification line had not yet reached his farm. You have to understand what Wendell Vandermere had just learned, and why he was the only farmer in Tioga County who knew it. If you're enjoying this story so far, don't forget to hit the like button and subscribe. Drop a comment telling me where in the world you're watching from. I love hearing from you. The Vandermere farm sat on a sloping pasture in Tioga County, Pennsylvania, 8 miles east of the village of Mansfield, in the rolling hill country where the Allegheny Plateau begins to break apart into the river valleys that run north toward New York. The land had been in the family since 1887, when Emmett's great-grandfather Cornelius Vandermere had purchased the original 140 acres from a Civil War widow for $2,040 in gold coin. Cornelius had built the original farmhouse in 1889. The barn had gone up in 1894. The dairy operation had started in 1903 with 8 Holstein cows and a hand-crank separator. By 1953, when Emmett's grandfather Wendell took over from his father Cornelius, the farm had grown to 240 acres and was running a herd of 62 milking Holsteins, a respectable operation for the region in that era. Emmett was born in 1963. He grew up on the farm. He left for college in 1981, came back in 1985 with a degree in agricultural economics from Penn State, and took over the dairy operation from his father Garrison in 1992. By 2021, he was 58 years old, had been farming the same ground for 36 years, and had spent the previous decade watching the dairy industry in northern Pennsylvania collapse around him. The numbers were brutal. In 2010, there had been 412 dairy farms in Tioga County. By 2020, there were 97. The small family operations had been disappearing the way candle flames disappear when the door opens on a winter night. Quickly, without ceremony. Emmett had survived because he had been careful. He had not borrowed against the farm to expand. He had paid off his father's mortgage in 2003 and had operated debt-free for 14 years. Then, in 2017, his wife Imogene had been diagnosed with stage 3 ovarian cancer. The treatment costs were not covered by their farm insurance policy. The hospital in Williamsport had required a payment plan. The chemotherapy alone had cost $93,000 over 14 months. The surgery had cost another $68,000. The recovery treatments had pushed the total past $200,000 by the end of 2018. Imogene had survived. The cancer had gone into remission in early 2019, but the farm had gone into debt for the first time since 2003. Emmett had taken out a commercial agricultural loan from First Allegheny Bank in November of 2017. The loan was $420,000, secured by the farm. The interest rate was variable, indexed to the prime rate plus 2.5 percentage points. The repayment schedule was structured around projected dairy income. The dairy income in 2018 had not met projections. Neither had 2019. By 2020, the milk price had collapsed to $14 per hundredweight, the lowest in 23 years. Emmett had fallen behind on the payments. The bank had restructured the loan twice. By February of 2021, the outstanding balance had grown to $492,000, and First Allegheny Bank had filed for foreclosure. Emmett was facing the loss of land that had been in his family for 134 years. He had no money to hire an attorney. He had no money to pay the loan. He had no realistic option except to sign the foreclosure papers and walk away. But on the night of February 28, 2021, 2 weeks before his court date, Emmett opened a drawer in his father's old roll-top desk and found something he had forgotten existed, a manila folder. Inside the folder, a single yellowed envelope. On the envelope, in his grandfather Wendell's careful copperplate handwriting, were 11 words, to be opened only when the bank comes to farm. Beneath the 11 words, in a different ink, in his father Garrison's looser handwriting, were 5 more. I never had to. GV 1989. Emmett held the envelope for a long time. Then he put it back in the folder. He put the folder on the kitchen table. He sat down across from it. He looked at it for the rest of the night. He did not open it. Not yet. To understand what was inside that envelope, you have to understand what was happening in American agricultural lending in the autumn of 1953. And you have to understand what made Wendell Vandermere different from every other farmer in Tioga County that year. In November 1953, the United States was in the early stages of a structural shift in farm credit. The post-war boom had brought rapid mechanization to American agriculture. Tractors had replaced horses. Milking machines had replaced hand milking. Bulk tanks had replaced milk cans. The capital cost of running a modern farm had tripled in 8 years, and the family farms that wanted to keep up were borrowing money at unprecedented rates. Most of those farmers borrowed from local banks, including a small institution in Mansfield, Pennsylvania called Tioga County Savings and Trust. Tioga County Savings had been founded in 1894 and had served the local farming community for nearly 60 years. By 1953, it held the agricultural loans of approximately 400 Tioga County farms. What most of those farmers did not know, what almost no farmers in rural Pennsylvania knew in 1953, was that the bank's loan agreements contain a clause buried on page 7 of the standard 14-page contract. The clause was titled, in small print, Limitation of Foreclosure Rights under State Statute 47 to 1953. The clause referenced a Pennsylvania state law that had been passed earlier that same year, Senate Bill 47, the Agricultural Land Protection Act of 1953, which prohibited a commercial bank from foreclosing on a family-operated dairy farm of less than 300 acres if the foreclosure would result in the loss of the property's milk production license, unless and until the bank had first offered the farmer a structured workout plan with no less than 7 years of restructured payments. And unless the farmer had refused that workout plan in writing. The law had been passed at the urging of the Pennsylvania Grange, in response to a wave of foreclosures across the dairy belt in 1951 and 1952. It had been signed by Governor John Fine on June 14, 1953. It had taken effect on September 1, 1953. The law had never been enforced. It had never been enforced because the banks knew about it and the farmers did not. The banks had drafted their loan agreements to reference the law in such small print, in such complex legal language, that no farmer who signed those contracts had any idea what protections he held. And when the banks did move to foreclose, they simply did not mention the law. The farmers signed foreclosure papers, lost their farms, and the law slept undisturbed in the Pennsylvania State Code. Wendell Vandermere knew about the law. He knew about it because his cousin, Harlan Vandermere, was a legislative aide who had drafted the original language of the bill in the office of State Senator Harold Plum in Harrisburg. Harlan had visited Wendell in October of 1953, 6 weeks after the law took effect. He had brought a copy of the final statute. He had explained to Wendell what it meant. He had also explained something else. Harlan had told Wendell that the banks were quietly drafting their loan agreements to neutralize the law, that the legal departments of every major bank in Pennsylvania had been coordinating on language that would obscure protection from the farmers who signed the contracts, that the law would never be invoked because nobody who needed it would ever know it existed. Harlan had told Wendell this in confidence. Late at night, at the Vandermere kitchen table, after 3 glasses of bourbon and a long silence in which neither man had spoken, Wendell had thanked his cousin. He had walked Harlan to the door. He had stood on the porch and watched the taillights of Harlan's car disappear down the dirt road. Then he went back into the house. He had sat down at the kitchen table. He had taken out a sheet of stationery and a fountain pen, and he had written a letter. The letter was 16 pages long. It explained the law. It cited the specific section numbers. It described the specific clause in the bank loan agreements. It explained how to invoke the law in court. It named 4 cases pending in eastern Pennsylvania in which the law could have been invoked but had not been. It included a copy of the relevant statutory language, which Wendell had hand-copied from Harlan's document while Harlan had still been in the house, before he had told Harlan the document needed to be returned. When the letter was finished, Wendell sealed it in an envelope. He addressed it not to anyone alive at the time, but to a future Vandermere who might one day need it. He gave the envelope to his eldest son, Garrison, who was 16 years old. He told Garrison to keep it. He told Garrison never to open it unless the bank came for farm. Garrison kept it for 63 years. He never had to open it. When Garrison died in 2016, he gave it to Emmett. He said only one sentence on his deathbed about the envelope. Don't open it unless they come for you. Emmett kept it for another 5 years. On the night of February 28, 2021, he sat at his kitchen table and looked at the envelope and could not bring himself to break the seal. He waited 2 more weeks. On the morning of March 14, 2021, in the parking lot of the Tioga County Courthouse, he finally cut the seal with a folding knife. What he read changed everything. The 2 weeks between Emmett's discovery of the envelope and his appearance in court were the longest of his life. He did not open the envelope during those 2 weeks. He told himself it was because he wanted to honor his grandfather's instruction, which had been precise, to be opened only when the bank comes for farm. The bank had filed papers, but the bank had not yet come. The court date had not yet arrived. The seal would hold until the seal was needed, but the truth was simpler than that. Emmett was afraid of what was inside. He did not know if the letter would help. His grandfather had been dead for 42 years. The world had changed. Laws had changed. Banks had changed. Whatever Wendell Vandermere had written in 1953 might mean nothing in 2021. It might be sentimental. It might be a final blessing, a piece of grandfatherly advice, a verse from Scripture. It might be useless. If the letter was useless, Emmett would lose a farm, and he would lose the last thing his grandfather and his father had left him, the belief that the envelope was something more than paper. Imogene asked him about it twice during those 2 weeks. She had been with him when he found the envelope. She knew what it was. She knew what was at stake. Emmett, what if you open it tonight? What if it tells you to do something specific? You'd have time to prepare. What if it tells me to do nothing? What if it's just a letter saying he loved us? Then I broken the seal, and I got nothing left. Emmett, the seal is a seal. It's not magic. What's inside the envelope is the same whether you open it now or you open it in the parking lot. He looked at her for a long time across the kitchen table. The seal is the last thing my grandfather did with his hands. The last thing he made. I'm not going to break it until I have to. Imogene did not press him further. She had learned, over 33 years of marriage, when to push and when to wait. She waited. On March 1st, Emmett drove to the offices of 3 different attorneys in Wellsboro, the county seat. None of them would take his case. 2 said the foreclosure was straightforward. The third said he would need a $15,000 retainer, which Emmett did not have. On March 4th, Emmett drove to the legal aid office in Williamsport. They told him legal aid did not handle commercial foreclosures. On March 7th, Emmett went to his state representative's office. The representative was not in. Nobody called back. On March 10th, Emmett went to the Tioga County Historical Society and spent 6 hours reading old issues of the Mansfield Advertiser from 1953. He was looking for anything that might give him a clue about what his grandfather had known. He did not find it. On March 12th, 2 days before the hearing, Emmett walked out to his grandfather's grave in the family cemetery on the back 40 acres. He stood there for a long time. He talked to his grandfather. He told him about Imogene's cancer. He told him about the loan. He told him about the foreclosure papers. He told him he was afraid to open the letter. The wind moved through the bare branches of the elm tree above the grave. A pair of crows lifted from the far fence and moved west across the gray sky. Emmett stood with his hands in his pockets and waited for an answer that did not come, because his grandfather had been dead for 42 years, and the only answer Wendell Vandermere had left was sealed in an envelope on a kitchen table 8 miles away. On the morning of March 14th, Emmett ate breakfast with Imogene. He put on his only suit, the one he had worn at Garrison's funeral 5 years earlier, the one Imogene had pressed for him the night before. He picked up the manila folder from the kitchen table. He drove to the courthouse. He parked in the lot. He sat in the truck. He took out the folding knife. He cut the seal. He read the letter. When he finished reading, he sat in the truck for 10 more minutes without moving. Then he put the letter back in the envelope back in the folder, and the folder under his arm. He walked into the courthouse. He was no longer afraid that, if you're hooked on this story, make sure to subscribe and turn on notifications so you never miss an upload. Your support means everything and helps me bring you more emotional stories like this one. Judge Harlan Pickering had been on the Tioga County Court of Common Pleas for 19 years. He was 66 years old. He was 3 years from mandatory retirement. He had presided over more than 400 foreclosure proceedings. He had a reputation for moving cases quickly and for granting bank petitions efficiently when the documentation was in order. The documentation in First Allegheny Bank versus Vandermere was in order. He had reviewed it the night before. He intended to grant the foreclosure within 15 minutes. Roy Thurmond, the bank's attorney, had arrived at the courthouse at 8:30 in the morning. He had filed 317 successful foreclosures over 11 years. He had a routine. He had a script. He expected to be back at his office in Williamsport by lunchtime. Emmett Vandermere arrived at 8:55. He sat alone at the defendant's table. He did not speak to anyone. He set the manila folder on the table in front of him. He opened it. He took out the envelope. He set the envelope beside the folder. The hearing was called at 9:14. Roy Thurmond presented the bank's case in 11 minutes. He referenced the loan documents. He referenced the payment history. He referenced the default notices. He requested an order of foreclosure on the property described in Exhibit A, 240 acres in Tioga County, current parcel identification number 8,847 to 203, in the name of Emmett Wendell Vandermere. Judge Pickering looked at Emmett. Mr. Vandermere, do you have any response to the bank's petition? Emmett stood up. He held the manila folder in his left hand. Your Honor, I would like to enter a document into the record. What document? A letter, Your Honor, written by my grandfather, Wendell Vandermere, on November 11, 1953. Roy Thurmond made a small sound, a dismissive exhale, almost a laugh. Judge Pickering's expression did not change. Mr. Vandermere, I am not certain what relevance a 68-year-old letter has to a commercial foreclosure proceeding. Your Honor, the letter cites Pennsylvania Senate Bill 47, the Agricultural Land Protection Act of 1953, which prohibits a commercial bank from foreclosing on a family-operated dairy farm of less than 300 acres if the foreclosure will result in the loss of the property's milk production license, unless the bank has first offered a structured workout plan of no less than 7 years, and the farmer has refused that workout plan in writing. The courtroom went silent. Judge Pickering leaned forward slowly. Mr. Vandermere, I am familiar with most Pennsylvania agricultural statutes. I have never heard of Senate Bill 47 of 1953. Your Honor, I have a copy of the statutory language with me. My grandfather hand-copied it from a draft of the bill provided by the original legislative aide who drafted it. I have also brought a printout of the current Pennsylvania State Code, Section 47, paragraphs 1 through 14, which I obtained yesterday from the Tioga County Law Library. Emmett took 2 documents out of the folder. He handed them to the bailiff. The bailiff handed them to the judge. Judge Pickering read the first document. Then he read the second. He read them again. He looked up at Roy Thurmond. Counselor, Your Honor, are you familiar with Senate Bill 47 of 1953? Roy Thurmond hesitated. The hesitation lasted approximately 3 seconds. In a foreclosure proceeding, 3 seconds is a long time. Your Honor, I am not personally familiar with that specific statute, but I would note that the bank's loan documents are standard commercial agricultural agreements that comply with all current Pennsylvania regulations. That was not my question, Counselor. My question was whether you are familiar with this statute. Your Honor, I have not studied that specific. Yes or no, Counselor? No, Your Honor. Judge Pickering looked at the documents again. He looked at the loan agreement that Roy Thurmond had submitted as part of the bank's exhibits. He turned to page 7. He read for 30 seconds. The courtroom was completely silent. Then he set the document down. Counselor, on page 7 of your loan agreement, paragraph 14, subsection C, your bank's contract specifically references limitation of foreclosure rights under State Statute 47 to 1953. That is the exact statute the defendant has just cited. Are you telling this court that you submitted a foreclosure petition without reviewing the statutory clause that your own loan agreement specifically references? Roy Thurmond did not answer. Counselor, I asked you a question. Your Honor, the reference on page 7 that is a standard boilerplate clause that is a clause that explicitly limits your client's right to foreclose on this property. Did you offer the defendant a 7-year structured workout plan? Your Honor, the bank restructured the loan twice. Did you offer the defendant a workout plan that complied with the requirements of Senate Bill 47 of 1953? Your Honor, that statute is, to my knowledge, a dormant law that has not been enforced in... It is in your contract, Counselor. Your client wrote it into the contract. Your client referenced the specific section number. Your client is bound by the clause in their own document. Did you, or did you not, offer this defendant a workout plan that complied with the requirements specified in your own loan agreement? The silence in the courtroom lasted 7 seconds. No, Your Honor. Judge Harlan Pickering looked at Roy Thurmond for a long moment. Then he looked at Emmett Vandermere. Then he did something that no one in the Tioga County Courthouse had ever seen him do in 19 years on the bench. He took off his glasses. He set them on the desk. He looked directly at Emmett. Mr. Vandermere. Yes, Your Honor. On behalf of this court, and I want this on the record, I owe you an apology. He paused. He looked down at the documents. I read the bank's petition last night. I intended to grant the foreclosure this morning within 15 minutes. I did not review the loan agreement carefully enough to notice the reference to Senate Bill 47. I did not investigate the underlying statute. If you had not brought your grandfather's letter into this courtroom this morning, I would have signed a foreclosure order, and your family's farm, which I now understand has been in your family since 1887, would have been seized by a bank that had no legal right to seize it. He paused again. That is a failure of this court. It is my failure, and I apologize to you for it. Emmett Vandermere stood at the defendant's table with his manila folder in his left hand and his grandfather's envelope in his right. He nodded slowly. He did not say anything. He could not say anything. His throat had closed. Judge Pickering turned back to Roy Thurmond. The bank's petition for foreclosure is denied. The bank is ordered to offer the defendant a structured workout plan in compliance with Senate Bill 47 of 1953. The bank is further ordered to show cause within 30 days why this matter should not be referred to the Pennsylvania Attorney General's office for review of the bank's loan practices regarding the statutory clause referenced in their own contracts. Counselor, I would advise you consult with your firm's senior partners before that show cause hearing. This proceeding is adjourned. He banged the gavel. The courtroom did not move for a full 10 seconds. Then the bailiff cleared his throat. People began to stand. Roy Thurmond gathered his papers without looking at anyone. Emmett Vandermere remained at the defendant's table, holding the envelope until the courtroom had emptied. He walked out into the hallway. Imogene was waiting for him by the bench outside the courtroom door. She had not been allowed inside. She had been waiting for 43 minutes. She stood up when she saw his face. Emmett, what happened? The judge apologized. What? The judge apologized. In open court. To me. Emmett. We didn't lose the farm. Imogene. We didn't lose the farm. She put her arms around him. He held her there in the hallway of the Tioga County Courthouse for a long time, and neither of them spoke, because there was nothing left that needed to be said. The letter that Emmett Vandermere read in his pickup truck on the morning of March 14, 2021, has now been entered into the permanent record of the Tioga County Court of Common Pleas. It is also held in the archives of the Pennsylvania Historical Society, the Penn State University Library Special Collections, and the Pennsylvania State Bar Association's records of significant agricultural law cases. The letter was 16 pages long. The first 3 pages explain the history of Senate Bill 47, how it had been drafted, how it had been passed, and how it had been deliberately obscured by the banking industry through the use of small print boilerplate references to a statute most farmers would never investigate. The middle 9 pages contain the full statutory text, hand copy from Harlan Vandermere's original draft, with explanatory notes in Wendell's handwriting in the margins describing how each section could be invoked in court and what evidence would be required. The final 4 pages were a personal letter from Wendell to whichever Vandermere descendant might one day need the protections the letter described. The personal section is the part that Emmett later allowed to be reproduced in the Pennsylvania Historical Society archive. The relevant passages read as follows. If you are reading this letter, then the bank has come to farm. I am sorry. I had hoped you would never need this letter. But I have known since October 1953 that the bank would come for someone eventually, and that whichever Vandermere was running the farm at that time would need be ready. The law I am describing in this letter was written to protect us. The bank has buried it in their contracts in a way that makes it nearly impossible to find. Most farmers will never know it exists. The banks are counting on that. Do not let them count on you. Stand in the courtroom. Cite the statute. Show the judge the language in their own contract. The law is on your side. It has been on our side since 1953. They have just been hoping nobody would notice. The farm has been in our family since 1887. It will stay in our family for as long as you need this letter to keep it. After that, it is yours to do with as you see fit. But while you have it, hold on to it. Hold on to it the way Cornelius held on to it in 1887, the way I held on to it in 1953, the way your father will hold on to it after me, the way you will hold on to it after him. Some things do not belong to us. We hold them for the next generation. The farm is one of those things. Your grandfather, Wendell Vandermere, November 11th, 1953. The aftermath of the March 14th hearing unfolded faster than anyone expected. Within 72 hours, the Pennsylvania Banking Department had opened a formal review of all First Allegheny Bank commercial agricultural loans. Since 2010, the review identified 147 loans in which the Senate Bill 47 clause had been included, but the corresponding statutory protections had never been offered. 17 of those loans were in foreclosure proceedings. All 17 were halted. Within 30 days, First Allegheny Bank's regional office in Williamsport was closed by the bank's holding company. Citing an internal compliance review, Roy Thurman submitted his resignation on April 8, 2021. He has not practiced law since. Within 90 days, the Pennsylvania Attorney General's office had referred the broader pattern to the U.S. Office of the Comptroller of the Currency, which initiated a federal review of agricultural lending practices across the eastern dairy belt. Within 1 year, Senate Bill 47 of 1953 had been invoked successfully in court 43 times across Pennsylvania. The statute, dormant for 68 years, had become one of the most cited agricultural protection laws in the state code. Judge Harlan Pickering retired from the bench in October of 2024, 3 years after his apology to Emmett Vandermere. In his retirement address to the Tioga County Bar Association, he referenced the Vandermere case directly. The transcript of that speech was published in the Pennsylvania Law Journal. The relevant passage reads, "In 19 years on the bench, the most important thing I learned was something I learned in a single morning in March of 2021. When a dairy farmer named Emmett Vandermere walked into my courtroom with a letter his grandfather had written 68 years earlier. That letter taught me that the law sleeps when nobody invokes it, and that some sleeps last for generations, and that the work of justice depends on people who are willing to remember the things the system has forgotten. I owe that farmer my final and permanent gratitude." Emmett Vandermere is 63 years old now. He still farms the 240 acres in Tioga County. The dairy operation is smaller than it used to be, 40 milking Holsteins instead of 62, but it is debt-free. The structured workout plan ordered by Judge Pickering reduced the outstanding loan balance through a combination of forgiven interest and extended amortization. Emmett completed the final payment on the restructured loan in September of 2025. The farm is now owned outright, as it had been when his father Garrison handed it to him in 1992. Imogene is still in remission. She is 61 years old. She works in the farm office 3 days a week. She handles the books that Emmett used to handle himself before he learned, in March of 2021, that his time was better spent on things that nobody else could do. Their daughter, Adelaide Vandermere, is 34 years old. She lives in Pittsburgh, where she works as an attorney specializing in agricultural law. She did not start out in agricultural law. She was a corporate litigator in a downtown firm until March of 2021, when she watched her father stand in a courtroom with a 68-year-old letter and changed the way Pennsylvania lending law was understood. She quit her firm 6 months later. She enrolled in a continuing education program at Penn State Law. She passed the agricultural law certification exam in 2023. She has handled 14 Senate Bill 47 cases. She has won all 14. The original letter that Wendell Vandermere wrote on November 11, 1953, is now kept in a fireproof safe in the Vandermere farmhouse. The safe is in the basement, beside the roll-top desk that belonged to Garrison. The original envelope, with Wendell's 11-word inscription and Garrison's 5-word addition, sits beside the letter. Emmett has added a third inscription in his own handwriting, beneath his father's. I had to. EV 2021. He has not yet decided what he will tell Adelaide if she ever inherits the safe. He has not yet decided if she will need the letter. The world has changed. The law is enforced now. The clause in the loan agreements is no longer hidden. But he has decided that the letter will stay where it is. He has decided that some letters keep their value not because they are needed, but because they were once needed and because the next generation might need something different that we have not yet imagined. He has decided to write his own letter. He has not written it yet. He does not know what he will say. He knows only that whatever Wendell Vandermere put into the world in 1953, on the night his cousin Marlin drove away into the dark, was worth keeping for 68 years. And that sometimes the most important thing a man can leave for his descendants is a sealed envelope on which he has written, in his most careful hand, the 11 words that say, "I cannot help you with this directly, but I have left you something. Open it when you need it. Until then, hold the seal." That is the whole story. The farm is still standing. The letter is still in the safe. The law is still on the books. And in a fireproof safe in Tioga County, Pennsylvania, 3 generations of Vandermere men have written their names beneath a single sealed envelope. And the envelope is now empty and the next envelope has not yet been written. But it will be, because some things do not belong to us. We hold them for the next generation. The farm is one of those things. The letter is another. And the apology of a federal judge, delivered in open court on a March morning in 2021, is something that no Vandermere will ever forget. Sometimes the most powerful weapon in a courtroom is a letter that has waited 68 years for its moment. Sometimes the law is on your side and has been on your side for generations, and the only thing that has been missing is someone willing to stand up and say it. And sometimes a grandfather, writing by kerosene lamp at a kitchen table in the autumn of 1953, sees further into the future than the bankers and the lawyers and the judges who will come after him. Wendell Vandermere saw it, and his grandson, 68 years later, finally read the letter. Thank you so much for watching until the end. If you love this story, check out the other videos on your screen now. I think you'll really enjoy them. And don't forget to subscribe if you haven't already. See you in the next story.